Hello everyone, welcome to another episode of Mind Map. Today's topic of discussion is constitutional amendments. First of all, we will discuss about the introduction of the topic. Then we will discuss about constitutional provisions, types of amendments, procedure for amendment, restrictions to Parliament's amending power. First of all, moving on to the introduction of the topic. Like any other written constitution in the world, the Constitution of India also provides for its amendment in order to adjust itself according to the changing conditions and needs. The Constitution gives the powers of amendment to the Parliament. It states that the Parliament may amend the Constitution by way of addition, variation, or repeal any provision in accordance with the procedure laid down for the purpose. However, the Parliament cannot amend those provisions which form the basic structure of the Constitution. This was ruled by the Supreme Court in the 𝐃𝐨𝐰𝐬𝐧𝐥𝐨𝐚𝐝 case 1973. Now moving on to constitutional provisions. Part 20, Article 368 of the Indian Constitution deals with the procedure and powers of Parliament to amend the Constitution. It keeps the Parliament's arbitrary power under check. Article 368 of the Constitution sets forth the mechanism for amending the Constitution, which states that an amendment can only be commenced by introducing a bill in either House of Parliament, which must be passed by both. Now let's discuss about types of amendments. The list of types of amendments can be found below. There are three ways in which the Constitution can be amended. Amendment by simple majority of the Parliament, amendment by special majority of the Parliament, and amendment by special majority of the Parliament and the ratification of at least half of the state legislators. First is simple majority. A number of provisions in the Constitution can be amended by a simple majority of the two houses of Parliament outside the scope of Article 368. These provisions include formation of new states and alteration of areas, boundaries, or names of existing states, abolition or creation of legislative councils in states, use of official language, citizenship acquisition and termination, elections to Parliament and state legislators, Fifth Schedule, administration of scheduled areas and scheduled tribes, and Sixth Schedule, administration of tribal areas. Second is special majority. Under Article 368(2), Parliament can amend the Constitution by passing a bill with a special majority. Fundamental rights and directive principles of state policy are the two most important provisions that can be amended by the special majority, but the amendments should be within basic structure of the Constitution. All provisions that do not require ratification by states and those that come directly under the purview of Article 368 can be amended by the special majority. Third is special majority with the consent of half of the states. Those provisions of the Constitution which are related to the federal structure of the polity can only be amended by a special majority of the Parliament and also with the consent of half of the state legislators by a simple majority. Important provisions that require ratification by the states include the election of President, Supreme Court and High Courts, representation of states in Parliament, distribution of legislative powers between the Union and the states, and the extent of executive power of the Union and the states. Most importantly, an amendment to Article 368 itself requires ratification by the states. Now let's have a look at the procedure for amendment. The procedure for the amendment of the Constitution as laid down under Article 368 is as follows. An amendment of the Constitution can be initiated only by the introduction of a bill for the purpose in either House of Parliament and not in the state legislators. The bill can be introduced either by a minister or by a private member and does not require prior permission of the President. The bill must be passed in each house by a special majority, that is, a majority of the total membership of the house and a majority of 2/3 of the members of the house present and voting. Each house must pass the bill separately. In case of a disagreement between the two houses, there is no provision for holding a joint sitting of the two houses for the purpose of deliberation and passage of the bill. If the bill seeks to amend the federal provisions of the Constitution, it must also be ratified by the legislators of half of the states by a simple majority. After duly passed by both the houses of Parliament and ratified by the state legislators, where necessary, the bill is presented to the President for assent. The President must give his assent to the bill. He can neither withhold his assent to the bill nor return the bill to the Parliament for reconsideration. After the President's assent, the bill becomes an act, that is, a Constitutional Amendment Act, and the Constitution stands amended in accordance with the terms of the Act. Now lastly, moving on to restrictions to Parliament's amending power. In the landmark 𝐃𝐨𝐰𝐧𝐥𝐨𝐚𝐝 case 1973, the Supreme Court has ruled that Parliament has the power to amend any part of the Constitution, but it cannot alter the basic structure of the Constitution. The constituents of basic structure are not clearly defined by the court. However, it has been interpreted to provisions like values enshrined in preamble like secularism, equality, etc., federalism, separation of power, independent judiciary, rule of law, etc. Now moving on to practice questions. First of all, prelims question that was asked in 2013 exam also. Consider the following statements. 1. An amendment to the Constitution of India can be initiated by an introduction of a bill in the Lok Sabha only. 2. If such an amendment seeks to make changes in the federal character of the Constitution, the amendment also requires to be ratified by the legislator of all the states of India. Which of the statements given above is or are correct? 1 only, 2 only, both 1 and 2, or neither 1 nor 2. And now mains question. Parliament's power to amend the Constitution is limited power and it cannot be enlarged into absolute power. In light of this statement, explain whether Parliament under Article 368 of the Constitution can destroy the basic structure of the Constitution by expanding its amending power. So that's all for today. Stay tuned for the next episode. Thanks for watching.